Facebook and YouTube. I'm here at the Jefferson County Downtown Courthouse here for Proceed Day. I'm here with two attorneys. Introduce yourself, gentlemen.
Yeah, I'm Joe Strickland.
Not Matt Tower.
Yeah, so attorneys, tell me about what is Proceed Day?
Yeah, but Proceed Day, today is actually for probate court. It was organized by Judge Blanchard to give citizens a chance to speak briefly with a lawyer about their probate matter. And probate covers a lot of different areas. Most people think of it as a situation where family members passed away and their estate needs management after their death, but it also covers situations involving incapacity where someone may have dementia or some other type of illness where they can't manage their or financial affairs. And so that can be helped by the probate court as well, and several other areas that Matt can discuss.
Okay, well, I always like to start off, especially I always do my interviews with attorneys, and I've done some interviews in the past with probate lawyers, is give you a situation. So what happens in Jefferson County if a person died without a will?
Without a will.
Yeah, just take me through that.
Okay. So if a Jefferson County resident dies without a will and their estate has to be open, which means there are assets left that are only in the decedent's name. Okay. So you have to do something with them. Nobody has authority to do anything with those assets. So you have to go to court, open the estate, and get authority to deal with those assets. So if there's no will, the process is called an administration. Okay. So a petition is a petition process through probate court where you're asking the court to appoint an administrator for the estate who would have the authority to go out and marshal the assets, deal with those, and then in the end, those funds or property, whatever's part of the estate, would be distributed to the decedent's next of kin.
Two situations I guess I could somewhat think of where I think a person who couldn't afford an attorney is when a loved one passed away. The two instant places people go is first the bank, and they realize that their loved one didn't have anyone else on the account, so that would have to go to probate, of course.
Usually, yes, sir. That would be an asset. It's stuck. It's only in the decedent's name. No one has the authority to do anything with that account. And there's some exceptions and things like that, but for the most part, yes, that would be a situation where the estate would have to be open and the administrator would be given the authority to deal with that financial asset.
We have found that over the years, most husbands and wives will naturally keep their assets either jointly or have a spouse named as beneficiary. So in a lot of cases, not every case, but many cases, if it's one of the spouses that passes, you'll find that if they own a home, it's a joint proprietor survivorship. If there's a checking account, it'll probably be a household management account. They manage together with both spouses on it. If there's life insurance, the spouse will be named as beneficiary. And so in those cases, that would be what we call a non-probate estate. Everything flows naturally. And so one of the things that we work with counsel people is, to the largest extent possible, to make sure that there is a beneficiary. Say you just have one spouse remaining, or in this case a parent, one parent remaining with children. Make sure if the intent is that an asset goes to the children, like a financial asset, like a checking account. If the children, if they're responsible children, then they're named on there as either a pay on death beneficiary or joint owner. Every case is different whether that's appropriate. But there's several opportunities to make children beneficiary. But be careful, because sometimes there's tax consequences for doing that. For example, let's say somebody bought a house years and years ago for a little amount of money, and now the house is increased in value. You don't want to automatically put the children on the deed because there could be a tax problem with that if the house is ever sold. So always check with a probate lawyer or a tax lawyer to see if the situation is really the death or making a change on that.
Well, I guess another unique scenario I could kind of think about is, say for instance, the person was not married, but they had multiple children, and then there was property, and that gets into who gets the home and who is the, what they call it, the direct decadent, is that the best word?
Yeah, the personal representative,
Yeah.
the executive.
Mhm.
That is a clear case where it's super important to have a will.
Okay.
The state of Alabama has essentially written a will or a chart of who gets what, but many times it does not match what people actually do want. So there's a formula of a certain percentage. In a normal case, it might be to the spouse, but that's only if there's no children. The children actually get a percentage. If there's a second marriage situation where some of the children aren't from both spouses, then a whole different formula takes place that might not match what the person wants. So really critical to have a will. There's extra complexities in probate court and extra expenses if you don't have a will. So even a simple, straightforward will would be better than no will.
And like Joe said, if you die without a will, the people that inherit from you may not be who you really want to get your stuff, right? So that's a problem sometimes. And if there is a last will and testament, you choose who your beneficiaries are. So that's, Joe was that's what he was saying, and that's certainly what we would all agree with, because you want to be able to control where your stuff goes, and the only way to do that is to have a last will and testament.
Okay, I'll give you another third unique scenario. Say that I went online, or I just Googled a will back in 2018. At that time, I saw, oh man, I could just set a will up. I can plug these in without even consulting an attorney because I see it on TV with the advertisements. Then maybe like a couple of years later, I decide, well, I don't want that will and do another will. But after I pass away, both wills are discovered. Can you talk about how that situation plays out in probate?
Typically, the later will would control, because there's usually language when it says, I hereby revoke any and all prior wills. Usually that language is in there. But, just, we want to caution everyone in terms of doing online legal forms, including wills, because the Alabama statutes control Alabama wills. Okay? When you go to a legal Zoom or something of that nature, you may be actually drafting a will that's not Alabama specific. It doesn't have Alabama terms and laws and things like that in it. So you may have even though you have a will, there may be a problem with that will because it does not meet Alabama's standards. So that's really important. But if there are two wills that sort of rise to the surface when someone passes, typically the later will is the one you look at.
And that's in the term. The official term would be last will and testament. That last will, means the most recent. In every will form, it would say, probably the first line, I hereby revoke any previous will. So the last will would be the one that the judge would look at, even if that sentence is missing. But it is super critical, just as Matt said, to at least make sure it's looked at by a lawyer. One of our recent judges told us recently at a seminar, and he had never seen a homegrown will that actually checked every box and hit all the things that it should hit. Even just a simple sentence being left out one might cause you to have a delay in selling a house, for example. Or maybe the wrong person being appointed. Or maybe someone who's a beneficiary has passed away, but there's not the right language to make sure it goes to their children. Or do you even want that? So, there's lots of different things that can happen that are unintended because wills have to last a long time. Somebody might do their will, pass away 25, 30 years in the future. And so you want to make sure that the will is always matches. And I found in my practice that typically that might change every 5 years, certainly I would say every 10 years. You might need an update. My wife and I did one where we named our fathers in some important positions to take care of our estate. This was when the kids were little. And And now the kids are old enough to do it themselves, and the dads could not do it. So that's one of those changes just in a 10-year span that made our wills dramatically different.
Now, well, I want to mention as well, if anybody would like to come down to probate court right now, they will be here until 11. If you want to meet with these gentlemen and they can discuss your situation specifically, and they're also at the Bessemer courthouse as well. So I want to mention that to the live audience while I'm taping. I guess, and just a scenario, also, I want to go back to conditions that will possibly, let's just say it was just one will, like you said, they did an online will, and somebody contest the will. What, according to state of Alabama, how long can a person contest the will in the state of Alabama?
Usually, generally it's 6 months.
Okay.
Or you can contest the will before it's probated.
Okay.
There's different rules on that. But if the will is probated and the estate is open, there's usually a 6-month time frame there. But like I said, there are options to actually contest before the will is open. Things like that, so there's some disagreements there. But it's important to keep in time the time frame. And if you are interested in possibly, please see a lawyer, and that would be so they'll know what the time frame is.
Yes, and I guess another thing too, I guess a lot of people probably watching this like, man, is he an attorney? No, not an attorney. I'm actually a notary, but I can speak on it. That had certain situations where I remember, and I've been doing notaries for years, that a will can actually, like you said, be thrown out if it's not, of course, an online will, or there's this part in Alabama is called, I'm going to explain, called a self-proven affidavit.
Yeah. Well, first of all, to answer that first question, if a will meets all of Alabama standards, it's in writing, it's signed by the person who passed away, it has 2 witnesses, that's the minimum requirement, and it could be a valid will if all the other requirements from that. You notice I didn't say notary.
Okay.
A notary is not technically required, but it is critically important because if a will is signed by the person that wrote it, and also has 2 witnesses and a notary, and it's in special language, it's what's called a self-proving will. Now, self-proving is important because when you present the will to the court, if it's in that special form, and it's online, exactly what that form is. If it's a self-proving will with a notary, then you don't have to have a special hearing. The witnesses that sign the will don't have to come to court to swear out what happened in the will. It's assumed to be valid unless it's challenged. So a self-proving will is a standard part of any lawyer's form. Hopefully, if they get it online, it matches Alabama's self-proving will statute. Many times it doesn't, obviously, because we don't know where they're getting it from online. But so that's an important part. That's what a self-proving will is. It doesn't mean it can't be challenged, but it just meets the initial signature requirements to be admitted without extra testimony, assuming there's no objection.
And another thing too, I guess, and this, like I said, going back to my notary experience, is that a person, their state of mind while they're writing the will. Can you explain how important that is?
Yeah, there's a certain level of capacity that a testator has to have in order to execute a will. Okay. And a lot of times when you contest a will, most of the time, the contestant is questioning whether or not the testator had capacity at the time the will was signed. So as lawyers, we look at that. We want to make sure in our minds that the testator knows what they're doing and is capable of signing, because we want the documents to stand straight, right, when we do them. So yes, capacity is a huge piece of the puzzle when you're talking about signing, drafting, executing a will. Very, very important.
There's several pieces of capacity we'd like to look at. One is the person that's generally oriented, that can hold a conversation. They need to be able to express who the natural objects of their generosity would be. In other words, they need to be able to discuss my family, their family. Say, yes, I've got 4 children, here are their names, here's where they live. Do you have any grandchildren? If they say, not sure, if there's some hesitation or they can't discuss their family members, they might be having early Alzheimer's or something. So that might be a cautionary time. So they need to be able to discuss their family. They need to be able to know what they own. And know their address. How long have you lived at that address? Do you have any bank accounts or any other assets? They need to be able to discuss that. Thirdly, they need to be able to discuss how they want that to pass in a coherent way. So if they have those things, they know who they are and the family is, they know their assets, they can discuss how they want it to pass. But they need a lot of help in those areas. Sometimes if you have a husband and a wife, maybe one starting to have some issues, they can help each other, but each of them through the will has got to be able to really do that somewhat independently. Another element other than capacity that comes into play is called undue influence.
Oh,
It's where someone can be a family member, like a child, can be somebody who's serving as an agent under power of attorney, but someone's sort of helping and directing and suggesting what a person should do with their will. And that's to really be able, I've seen situations where it was a child, and it was super rare in my practice, but this particular child had encouraged a parent to change the will dramatically just a few days prior to her death. That favored them dramatically. And so that once they were actually, once I was brought to their attention that probably would not pass the court's judgment, that actually was withdrawn and settled, no litigation was needed. But sometimes that's a key factor in this, is capacity, and whether that means there's undue influence by someone who is what's called a confidential relationship, or there could be something technical with the will itself that's missing. So those are the 3 big ways that will be challenged is the capacity of influence or some kind of technical defect.
So, wills are more than just documents. It's a comprehensive legal document that the testator is doing that directs his estate. So it's really important. And there's so many issues that you need to think about and address in that process. The capacity issue, the undue influence issue, certain language in the will, very, very important. So, but the lawyer is trying to do everything they can to make sure the document is valid and that it can stand scrutiny. So a lot goes into the last will test.
And this should definitely be mentioned, not to get away from wills totally, but there's a lot of focus on wills and what happens after someone dies, but it's absolutely critical. Everybody watching this should make sure that they do the planning that's needed to make sure someone can manage their affairs during their life. And that's where it's called durable power of attorney. That can be in the area of finances, which is what most people think of when they think of power of attorney. But also medically, we make sure medical decisions. We make decisions at the very end of life or an advanced directive, healthcare or living will. If you ignore all those, bad things can happen. I remember very, very well a case I was appointed on where a man moved in to live with a child in an area, and they thought they had everything covered. But when that child needed to help their parent by going to the bank and cashing out a fund to pay for his care, it was determined that they did not have the power of attorney. And there was no way around it at the bank other than going through what's called a conservatorship. And it was also guardianship, conservatorship, guardianship in probate court. In a court can help with that, but it comes at a great expense. You got to close to line with an insurance company, you have to go back every 3 years for an accounting. Every time you do an accounting, there's court costs and attorneys for the parent each time. It's a very expensive process. It can be avoided with one signature on the property. So getting that document in place, having a trusted family member who serve as the agent and an alternate, is critically important, not to be overlooked.
Now, I guess when they come, let's just say somebody's coming here today, what beginning steps you all help them with? It's almost like a fresh out scenario, like I guess I'm getting a lot of scenarios this morning. My loved one passed away a week ago. We just buried him. You know, it's hard kind of trying to come down here to probate. First thing we need to make sure they be buried first. But we're coming to you just, where do I go next when I'm coming there asking you questions?
Well, then we talk about, did they have a will or not? Or did they not have a will? So that sort of dictates the journey that you take. But then you start talking about assets. What assets does the decedent have? Is it real property? We're talking about liquid financial type of assets. So we would talk about the process of opening the estate if needed. If there's assets that they can't get their hands on and they can't liquidate and can't manage, then we would talk about either probating the will or either like I said, the administration process earlier. So we would talk about what would be required for each of those steps if we determine that an estate needs to be opened.
Okay, and I got a question from somebody actually on Facebook. They said, I have my husband's will. He was an only child and both parents preceding him in death. He left everything to me, his wife. I have not probated the will. Am I required to?
Well, see, that sort of leads into the discussion of how the assets are titled. Yeah, when he died and how the assets are titled. My wife and I, right? All of our assets are jointly held.
Okay.
Like our bank accounts, both of our names are on. Our real property, both of our names are on.
Okay.
A certain language in there.
Okay.
So if I were to die first, I've got a will. But if I were to die first, all of our assets would pass automatically to her by what's called operational law. So I have a will, but in that scenario, the way our assets are titled, I don't have to probate my will. Because she can get her hands on all of the assets. So you have to determine what asset is there or not there that you can't access. So a lot of times with married couples, you don't need to probate the will. So that's when we would start talking about, well, let's talk about your assets. What did the decedent have? How are those assets titled? Are there beneficiary designations, co-owner designations? We would take a look at that and then make a decision whether or not we needed to probate the will.
And the passing of a spouse is one of those life events that automatically should trigger her to review her own estate. Because she has the documents in place to have her estate managed during her lifetime, the medical affairs managed, and pass on to the next generation that she should have. So that's one of those things that triggers a review automatically in my mind.
Well, another thing I want to throw at you as well while we're sitting here talking. I know this doesn't exist in Alabama anymore. What if we just common law, never married, but they lived in the house together? Even though they probably need to get married, but what can a person do? I know you look at if they're common law to make sure if they don't have a will in place or.
Well, yeah, the common law was done away with several years ago. Now there are some situations where you look at grandfathering in, but common law, you have to establish certain elements to establish a common law relationship. So what I would say is, if you're quote in a common law relationship and you want your partner to inherit, then you would have to do the last will and testament. Because if you die without one, that common law partner may not be recognized as the next of kin in Alabama law. because of all the changes.
Yeah, and even if they would, they would have to go through a whole process to establish that, so you're just making that an unnecessarily complex thing. A will would cover it.
Yeah.
Same thing with someone that wants their friends to have their estate or charity. That's not gonna happen automatically unless you do a will, or when you name those individuals or those entities as beneficiaries, which is rare.
So how long does it last? Like, say for instance, I give you that scenario. I'm coming in and I'm doing it on my own and not saying I'm hiring an attorney, but I'm walking through the footwork of doing it. How long right now, I know it varies in Jefferson County, just to get to the judge before? I guess that's the best thing.
Yeah, are you saying that after death, before you get to the judge?
What, after death? Like I come in, I see you, I go to probate court, file the necessary paperwork. How long does I get to the judge?
Well, you might not, if it's a properly drafted, self-approving will,
Mhm.
that is, a person has a will that has the two witnesses and the notary,
Mhm.
the client, let's say the surviving spouse, or whoever's named as personal representative, or exactly, all that means the same thing, they might never have to come to the courthouse.
Okay.
So as soon as a death certificate is available, and that is required, and the family signs the paperwork, that is, if it's nominated as personal representative, has to sign paperwork, each of the next of kin, whether the name is the beneficiary or not, they have to sign some paperwork or have notice of the process. If everybody signs their paperwork, as soon as the certificate comes, the lawyer can take it to the courthouse, meet with the staff clerks, they review the will, do an initial review, and typically in about half hour, you have your documents. The estate is open on that day without a hearing. The times that you need a hearing would be if there's a disagreement and you've got somebody not signing the paperwork. They say, well, I don't know how that will. I'm not going to sign anything that says I know this process is happening. So if a family member doesn't want to sign their paperwork, or if you have a minor child involved, or if you have a disabled person who has dementia, they can't sign their paperwork, and they're involved, or if maybe one of the next of kin is missing. Maybe they went to another state 20 years ago, nobody knows where they are, or even if they're alive, or how they're doing. Any of those cases would require a hearing. So typically, you would file a case, the lawyer would file a case, and the judge, and they would set a hearing date. I believe the document's about 2 months plus out. Is that about right?
Yes.
At least 8-10 weeks out.
So there could be a time when you have all your paperwork, and you think you're ready to go, but you may have to have a hearing to open the estate. So, I mean, it could be 2 or 3 months before it would just be sitting, and you're just waiting on your hearing date.
So it could be as fast as 10 days or 2 weeks. That's pretty straightforward. Or it could be several months if you have that hearing.
So one thing before I wrap up real quick is, and I say, I'm going to go back to the common law part, is that even if they're common law, they can't obtain the death certificate, correct? It's going to be hard for them to get.
It could be an issue.
Yeah.
But if they have the same address, they probably would be able to talk to them, especially if their name is personal representative on the document, same address, they might be able to work with the law department to get it. And that could be an issue. They might have to work with a family to actually get access to the copy. So another issue. That's one reason you have a personal representative name in the will, have an agent or a power of attorney. Good questions.
So if they show a deed, I know you feel all sorts of different. So if the name's on the deed to the house, the name on their bank accounts, their common law, would that help the person if they come to court to be named?
They probably wouldn't even need to well, they need a will, but they probably wouldn't have to probate the will.
Okay.
If they're on the house and it's joint with the wife survivor child,
Okay.
then there's a special type of language. That's most of the time if they buy it together, that's how you would type it.
Okay.
Occasionally, it could be a different way though, so you have to read it carefully. It could be what's called tenants in common. Maybe they each provided some of the down payment and they said, hey, if something happens to me, it goes to my kids. If something happens to you, they own one half. That's a different way of owning it. But if it's joint with right of survivorship, that means it automatically goes to the survivor joint owner. And if the banking accounts either have joint ownership or paid for death designation like a beneficiary, then they would have what's called a non-probate estate. They would not actually have an asset that needs the probate court to help it transfer. And so in that case, they might not have a probate court.
But that's why an asset analysis is critical when you're they're talking about possibly opening the estate or not. I mean, we have to research that. We have to look at what assets the decedent had and how they were titled. So that sort of dictates the next step.
And some people might not know, I remember very well, a longtime friend came, an elderly widow, and she lived in the same home for 40 years plus. It passed. And she said, oh, the house is joint. We lived there 40 years, it's joint. And then when we actually looked at the deed, she got that, everything like that. It was in his name alone. And she had no memory of that. And then she said, wait, he was Birmingham first. I came right after we married, and I guess he bought the house, and she totally forgotten the sequence. And so the actual documents are important. People get memories from favorite. So looking at it, having it reviewed by someone that knows what to look for, super important. You don't want surprises like that again, because in that case, we did have to probate it, otherwise we would not.
So I know we're here at Pro Say Day, but if they want to contact you all, how can they reach both of you all?
My firm is called Cornelius and Talley. Our phone number is 205-977-9911. And like I said, we focus a lot on probate matters and special needs planning. So that's really all we do. So, yeah.
It's same here, I'm a probate lawyer, that's all I do anymore, is Joseph Strickland, and my number is 205-249-1272, and that's a mobile text or call.
Well, attorneys, Strickland, thank you all for coming on. If you guys still want to come check it out, it's here to about 11 o'clock. Great free resource, Jefferson County. Take advantage of it, especially with wills and probates, like you said. Whenever you check out this world, if you don't want the state of Alabama to decide how it is, get a will.
Thanks, Charles.
Thank you all. Bye-bye.